Recently, I was speaking with an individual that felt like they had been harassed by their manager in their place of employment. And one of the things I began to explain to them is that harassment in all of its forms, whether it's sexual harassment or religious harassment or harassment based on race, or even someone teasing you about a disability that you may have, when harassment comes from a manager, it has a little different analysis than it does when it's coming from a coworker. Again, the coworker harassment requires that the employer know or should have known that the harassment was taking place. If the employer knew or should have known that the harassment was taking place and they did not take immediate and appropriate corrective action to cure it, then it could result in a cause finding, and that employer could be held liable for that harassment. Where it's different with a manager is it's not just a coworker or a fellow employee, it's a supervisor. When it comes down to supervisors and managers, there must be what the law refers to as tangible employment action. And again, this is where you would need the hands of a skilled lawyer that's skilled in this particular law to look at this. Tangible employment action requires that there was some alteration, something shifted about your employment. They cut your pay, they cut your hours, they moved you to another place in the building. Something happened as a result of your claim of discrimination or harassment by a particular manager. And if that tangible employment action is casually linked to the harassment, then there would generally be a finding, a cause finding, as the EEOC would say, or there would be a violation of the law. Again, if you have a tangible employment action and that action is causally or even casually linked to that tangible employment action, to that harassment, then there would generally be a cause finding under the law. If there is no connection, then the question would be, did the employer, if you will, or human resources, whomever, take care to correct the harassment to prevent that manager from harassing you again? If they did so, then and the person that has been harassed followed the processes, did everything that they were supposed to do, and all of the harm would have been avoided if they followed the processes, then generally there wouldn't be a finding under the law. But if the employer did not take the proper care, then generally there would be a finding under the law. And again, that's a little more detailed than most lawyers would know, because most lawyers, it's a very fine area of law, this employment law. So you need to sit and talk with a lawyer, but there is a different standard for managers and supervisors. It's different from co-workers, and it's even different from the owners or higher up officials in the organization. So you would certainly need to speak with an experienced employment lawyer.